Good morning, everyone. Hope everyone's well this morning. We'll
Good
get
morning.
started. Good morning, Ms. Greenhouse. Thank you for being
Thank
here
you.
this morning.
Thank you.
We will get started as soon as courtroom 2 is ready for us. Good morning, Mr. Haddad.
Hey, good morning, Judge.
Ms. Falk, good morning.
Good morning, Your Honor.
Morning, Judge.
Good morning, Mr. White.
We don't have anybody here yet, but we will let you know as soon as we do.
Okay, thank you. I have a couple of people here. I'm in G33 today. I have a couple of people here with me. I believe one is the victim in the alleged victim in the Joshua Evans case. I see that that's going to be a not guilty. Mr. White, is that going to be a waiver this morning?
Yes, Your Honor, that'll be a waiver.
Okay. Yes, sir. You're here for the Evans case? Mr. Evans is pleading not guilty. His case is going to be returned to the division judge, and you'll get notification of his next hearing date. I'm sure the solicitor's office will be in touch with you. I said, I'm sure the solicitor's office will be in touch with you, okay? All right, so I'm not gonna see him this morning, so you're free to go if you choose to. You're welcome. Let's see, also, is Mr. Misogynin then in with you?
Yes, Judge.
Yes, Judge, I'm here.
Yes, good morning. I also have someone on the Darian Price, position number 44. I see you have a not guilty, but it says bring to court. Are you going to be asking for a bond hearing or something this morning?
Your Honor, Mr. Price, after I advised him of all of his rights, insisted that he wanted to speak directly to Your Honor this morning. And so that's why I asked for him to be brought out today, but I believe the intent is still to plead not guilty, and I don't believe there's a need for a bond hearing this morning.
Okay, all right, that's fine. I just wanted to, I have someone in the court here with me that's on that case, and if I were not gonna see him today, I wanted to release her, but I'll just let you know, I'm not sure who this is, if it's the victim or not, Ms. Falk, but when we get to that case, I'll have her announce.
Yes, Your Honor.
So we'll be with you, ma'am. All right, court will be in recess, I guess, until someone's ready for us.
Okay, Judge, we ready to start.
Very good. Let's see, where would you all like to start this morning?
Got position 28, Mr. Harris.
And this is going to be a negotiated plea.
Okay, all right.
And this is, Mr. Harris, is that right?
That's correct, Judge. He is going to be a negotiated plea.
Very good. Good morning, Mr. Harris. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you please raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Harris. Thank you. Good morning, Mr. Nixon.
Good morning, Your Honor. State's recommendation is 12 months to serve 40 days, credit for time served 20 days. And that's from June 5th, 2025 until today. Balance probated, stay away from 325 Auburn Point Drive, Atlanta, and a $300 fine. That's for count one. As for count two, 12 months to serve concurrently with count one. And the state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
Ms. White?
Your Honor, we do stipulate for the purposes of the plea, and we just ask that, the $300 fine be converted to 30 hours of community service and that the probation, terminator go non-reporting once he's completed that.
Okay. Mr. Harris, it's my understanding that in case 25 CR 003196F, you wish to plead guilty to willful obstruction of law enforcement officers and criminal trespass. Is that correct?
Correct.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Harris, when you complete the 30 hours of community service, I'll have the probation terminate. So the sooner you get it done, the sooner you won't be on probation, okay?
Okay.
All right, good luck to you, sir.
Position 7, Mr. Brown.
Your Honor, that's going to be a negotiated plea.
Good morning, Mr. Brown. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Can you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? You have to speak.
Yes.
Okay, you can place your hand down. Thank you, Mr. Brown. Yes, Ms. Falk.
Yes, Your Honor. This defendant is charged with one count criminal trespass. The state's recommendation on that case is 12 months served 34 days, credit for time served 17 days from June 8th, 2025 until today. Balance suspended. Stay away from the CVS located at 2907 Main Street in East Point. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
So stipulated, Your Honor, nothing further.
Mr. Brown, it's my understanding that in case 25 CR 003248C, you wish to plead guilty to criminal trespass. Is that right?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by Mr. White. Are you happy with what he's done for you?
Yes.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Brown. You know you can't go back to that CVS in East Point, right?
Yes.
Okay, good luck to you, sir.
Thank you, Your Honor.
All right.
Well, maybe tomorrow morning, next 24 hours.
Position 34, Mr. Matt.
What are we doing with Mr. Mack today?
Good morning, Your Honor. After speaking with Mr. Mack, he needs more time to consider the state's offer. We are asking for Mr. Mack to be reset to the July 10th SAP calendar.
Okay, July 10th. I'm happy to reset him. He does does he have something else holding him, Mr.
Yes.
Misogyny?
Yes, he does, Your Honor.
Okay, very good. I'll see you back on July 10th, Mr. Mack.
Thank you.
You're welcome.
Position 41, Mr. Patterson.
Also a negotiated plea.
Yes, Judge.
Your Honor, on position 41, can we just briefly hold off on that one? We are trying to reach out to the victim to comply with Marcy's Law.
Okay, can we go to someone else for a little while? Courtroom 2. We'll be back with you, Mr. Patterson.
We go to ACDC, Judge.
Alright.
Okay. Good morning. Who do we have?
Morning, Your Honor. We have position number 20, Ms. Evans.
I'm sorry, say it again for me, please.
Position 20, Ms. Evans.
Okay, thank you.
And Your Honor, we'll have the same announcement on Miss Evans. I do sincerely apologize. We, the normal victim advocate was out and we had a little bit of a miscommunication.
Okay. Do we have the numbers of any others that you might need, Ms. Falk, so that?
So it's going to be all cases in which there is a victim. They're currently reaching out right now as we speak to get in contact with those victims. So if we could maybe stick to criminal trespass, the charges in which there's not usually a victim involved.
Your Honor, there's, I can suggest, the add-on calendar, Shankira Tolbert, Judge, it's a dog at large, that would be, I think, appropriate.
That would be perfect. Thank
And
you,
I have
PD.
one
Haddad.
other case, I'll find it in a second, Judge.
Okay.
Yeah. If she has the position numbers, we can
Okay.
work with it. No charges.
Ms. Falk, who is the alleged victim in position 44?
Position 44, Your Honor, the victim is going to be, just see, that one is Miss Bianca Kelly.
Is that you, ma'am? Miss Kelly's in court with me.
We can
so-
address that, Your Honor, if Mr. Price is here.
Do not have Price ready in the courtroom 2 yet.
But I know that they may have wanted to address the bond motion, which is why I didn't want Miss Kelly to be dismissed, if that was her.
Okay, so I'll just hold until we're ready. So you all just tell me where we need to go next.
We can, the
I'm
add-on.
right. I believe we said Miss Tolbert, and thank you, PD Haddad. That is ready to go.
Okay, and is this Ms. Tolbert here at ACDC? Good morning, Ms. Tolbert. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Speak up.
Yes, sir.
Okay, thank you, Ms. Tolbert. You can place your hand down. Yes, Ms. Falk.
Yes, Your Honor. On count 1, the reckless conduct, the state's recommendation is 12 months to serve 24 days, credit for time served 12 days. That will be from October 24th to October 26th of 2024 and June 16th of 2025 until today. The defense has requested 50 hours of community service in lieu of the fine, and she must complete the animalcourts.com online course. Count 2, it will be 12 months concurrent with count 1. The defense has opted into the 20 hours of community service on behalf of their client, and that is to run concurrent to count 1. Count 3 will be 12 months probated, a $125 fine concurrent. If Miss Tolbert has proof of that a Fulton County license has been obtained for her dog, that will satisfy the fine requirement. I'm not sure if she has any proof of that or still owns the dog.
She does not own the dog, Judge. I think the dog was basically taken by, I forgot the agency, Judge, but the county, animal control, sorry.
Animal
Judge.
control?
Yes.
Okay, if that is the case, the state will null pros count 3, Your Honor. So that will conclude that portion of the case. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea, and upon the taking of this plea, the state will null pros position 4.
Anything further, Mr. Dodd?
We stipulate, Judge, based on the nature of the charge, Judge, I would ask the court to consider terminating her probation upon completion of all the conditions, Judge.
State has no objection.
Okay, nothing further. Ms. Tolbert, it's my understanding that in case 23 CR 007908E, you wish to plead guilty to reckless conduct and dog at large. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Right.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Tolbert. As soon as you complete the community service hours, I'll have the probation terminate. So the sooner you get that done, the sooner you're not going to be on probation, okay?
Thank you, sir.
You're welcome. Good luck to you, ma'am.
Your Honor, I believe we are ready to move on to position 20. We have reached out to the victim on that case and received a response,
Okay,
And
which
Your
was
Honor-
Amber Evans.
Oh, great. And Judge, also want to let the court know, position 31, I believe, is appropriate to resolve with Lisa Jones. It's a criminal trespass.
okay, thank you. Good morning again, Ms. Evans. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you have to scooch up or speak up for me.
Yes.
Okay, very good. You can place your hand down. Thank you, Ms. Evans. Ms. Falk?
Yes, Your Honor. On the simple battery count 1, the recommendation is 12 months served 38 days, credit for time served 19 days from June 6, 2025 until today. Balance probated. No further contact with Amina Akram. 40 hours of community service and MHET. Count 2 will be 12 months on the disorderly conduct, will be 12 months served 38 days, credit for time served 19 days. Concurrent with count 1, we have had an opportunity to speak with Ms. Akram, and she does agree with the plea recommendation. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. We would like to sound for Ms. Amina Akram if she is here in the court.
If Ms. Akram is on the line and wishes to address the court, now is your opportunity. Does not appear so. Mr. Haddad?
Your Honor, we stipulate for purpose of the plea, I would just ask the court to consider waiving the probation fees, at least for the first couple months. Or on the back end, place on non-reporting, assuming all the conditions are completed, Judge.
Okay. Does she require the services of a social worker to assist with housing or anything of that nature, Mr.
Yes,
Haddad?
Judge, well, let me take that back. We provided her with housing information and also gonna follow up on a couple other leads, Judge, but we gave her the package.
Does she currently have housing at the present time?
No, not right now, Judge. We do have a couple of options for her. And we've given her information as to what to do upon release. As far as shelters, but there's programs out there that are gonna assist her there.
Okay, thank you. Nothing further, Ms. Evans. It's my understanding that in case 25 CR 003218A, you wish to plead guilty to simple battery and disorderly conduct. Is that correct? I'm sorry, you're gonna have to just answer yes or no for me, Ms. Evans, and I'll speak up a little bit. Are you under the- Okay, thank you. Thank you, Ms. Evans. Are you under the influence of any drugs or alcohol this morning?
No, I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Ms. Evans, I will have a social worker visit with you to assist with housing. I'm also going to waive the first 3 months of the probation fees to help you get and stay on your feet. And when you complete the terms of the probation, I'll have it go to a non-reporting status. So as soon as you get the community service done and have the MHET, then you won't be on reporting probation and won't have to pay any fees, okay?
Okay.
All right, good luck to you, Miss Evans.
Thank you. Go to position 31, Your Honor. Ms. Jones.
I'm sorry, say it again for me.
Position 31.
Also a negotiated plea.
It is, Judge. There's also an add-on on the calendar as noted, so it'll be a plea for both cases, Judge.
Okay, thank you. Good morning, Ms. Jones. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, speak up for me.
Yes, sir.
Thank you. You can place your hand down. Mr. Nixon?
Yes, Your Honor. With regard to the criminal trespass, this is, state's going to recommend 12 months to serve 40 days, credit for time served 20 days. That's from June 5th, 2025 until today. Balance suspended, stay away from 487 Old National Highway in Atlanta. As mentioned, this will be a global recommendation with regard to case 24 CR 006786J. As for count 1, state's recommended 12 months to serve 4 days, credit for time served 2 days. That's from September 30th, 2024 until October 1st, 2024. Balance probated along with alcohol, drug, and evaluation treatment. With regard to count 2, this will be 12 months to serve concurrently with count 1 and a stay away from 4894 Old National Highway in College Park. State would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
We stipulate, Judge, we ask the court to follow the state's recommendation as a negotiated plea. Our only request is either waive a couple months probation fees or at the back end, assuming she complies with everything, that's our non-reporting, Judge.
Okay. Ms. Jones, it's my understanding that in case 25 CR 003198J, you wish to plead guilty to criminal trespass. And in case 24 CR 006786J, you wish to plead guilty to possession of drug-related objects and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, I am.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Jones. When you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation and have to pay the fees, okay?
Okay.
All right, good luck to you, ma'am.
Judge, should the paperwork be sent to Ms. Young?
Yes,
Okay, all right, thank you.
thank you.
Got position 8 and 10, Mr. Coffey.
And this is a non-negotiated plea.
That's correct, Judge.
What's not negotiated about it?
We're just, the jail time.
Okay. Good morning, Mr. Coffey. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir?
Yes, Your Honor. How you doing?
I'm doing well, thank you, Mr. Coffey. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. Let's see, who do we have on from pretrial? Do we have anyone on from pretrial this morning? Oh, yeah, Ms. Washington, good morning.
Morning.
May I have, Mr. Coffey's, history, please?
Yes, Your Honor. There are 37 arrest cycles. The last arrest appeared to be for an FTA in April of this year. In March of this year, the defendant pled nolo to theft by shoplifting. There is an open pre-indicted case from December of last year for 2 counts of burglary, criminal damage to property in a second, and willful obstruction. There's a 2024 misdemeanor conviction for criminal trespass, willful obstruction, and simple assault. A separate 2024 misdemeanor conviction for criminal trespass, disorderly conduct, simple assault, and theft by taking. 2023 felony conviction for terroristic threat and an interference with government property. 2023 misdemeanor conviction for willful obstruction and disorderly conduct. 2020 felony conviction for terroristic threat and willful obstruction. There was an arrest in 2017 for theft by shoplifting. That case appeared to be dismissed. A 2017 felony conviction for aggravated assault, and a separate 2017 felony conviction for terroristic threat, willful obstruction, 2 counts of criminal damage to property, DUI, and an aggravated assault. There's also a 2014 misdemeanor conviction for theft by shoplifting.
Thank you, Ms.
That's
Washington.
all in the last 10 years. Okay.
Yes, Ms. Falk.
Yes, Your Honor. On the simple assault, criminal trespass, and willful obstruction, the defendant entered a plea before Your Honor on September 10th of 2024. He received balance probated, so he should technically still be on probation on that on September 10th, 2024. He received 30 days to serve on that case, and he had a no further contact with Bruce Griffin as part of that. And also he was ordered to pay restitution in the amount of $1,600. Previous to that, Your Honor, the defendant entered a plea on a simple assault, theft by taking, criminal trespass, and disorderly conduct. He entered that plea on October 22nd of 2024. That was also before Your Honor. And on that case, he received 86 days to serve, credit for time served 43 days. He was to stay away from Grady Hospital unless for medical treatment on that case, and have no further contact with Keisha Love and no further violent contact with any of the Grady staff. And he was to take an anti-theft course and participate and have an MHET. So that was just the last 2 cases that Your Honor heard involving this defendant. He should technically be on probation on both of those cases still. In our cases, there were several different incidents. The first one happened on November 1st of 2024 at the BP gas station at 464 Windsor Street. The defendant was taken into custody for property damage at that location. What he did was he ended up, let's see. On that date, he took various snacks, chips, and other items in an amount of $30. The officers tried to take him into custody. He started kicking the patrol car door, as well as spitting in the car multiple times, and had to be pepper sprayed as a result. So that was the theft by shoplifting, damage to property, and obstruction of an officer. On the next case that happened, the criminal trespass, that occurred May 17th of 2025. Officers responded to 884 Rose Circle and in regards to individuals who are unlawfully inside the residence. it was a realtor for Sovereign Realty and Management who came to that location trying to inspect the house, and a black male answered the door trying to persuade him to come in, and then he retreated and called 911. The defendant was found inside the house. There were several items taken from the home. Trash was left behind. The tub was completely filled with water, and the shower had blood on the floor. The final case, Your Honor, involved the defendant going to the Chevron gas station on April 28th, 2025 at 507 Joseph E. Lowry Boulevard and taking two Rita's beers in an amount of $8.90 and failing to pay for those items and then leaving the location. So that is the defendant's current cases. The reason the state asked for 90 days is mainly because he has kind of continued along a trajectory. The last plea that he took, he was given 82 days. And so the state did not feel that it was in the interest of justice to offer less time, being that he now has 3 additional cases. So that was the reason for the state's recommendation of 12 months served 90 days. That's all for the state.
Ms. Falk, do you happen to know, in regards to, and maybe this is better suited to go to probation, but if you do know, whether he has paid the restitution and in the September 10th criminal trespass plea that was taken?
I have absolutely no idea if he's met any of the requirements of probation. The information inside the system just says balance probated. It doesn't have any further updates as to whether he was terminated unsuccessfully or continues to be successful on probation.
Ms. Washington, is that something you can find out for me?
You want me to find out if he's currently on probation?
I know that he's on probation. I need to know if he is satisfying the terms of the probation, if he's paid any of the restitution or tried to pay any of the restitution back.
Oh, no, sir. I don't know. I don't have access to the misdemeanor probation information.
Okay, thank you. Yes, Mr. White.
Your Honor, Mr. Coffey's issues with the law stem from both homelessness and MH issues. We don't think that jail time is going to do anything in order to address that. Additionally, the two of the 3 charges are for less than $40 worth of food and drink. He has been in touch with Social Security and has an appointment next with them to get services. He's also in touch with PAD and Mercy Care, and our lead social worker, Lee Hampton, are all working with him and are working to get him an ID card and all of the things that he can need in housing. He would miss his Social Security hearing next week if he does this extra jail time. And additionally, we just don't think it's in the interest of justice. Jail time is not what he needs. It's not going to do anything for him or society going forward. So we just ask that he be given time served at this point. Thank you.
Your Honor, if I may, if Your Honor's decision is going to be based upon whether he's complied with probation, if you want to, we can hold this and I can reach out to probation and see if he's complied with the conditions.
Okay, well, I'll tell you, my concern is that Mr. Coffey's been in front of me twice. I have probably gone along with the recommendation of both the state and his counsel at the time. I've given him jail time previously. I understand what your argument that it won't do him any good, but at the same time, I can't go in the opposite direction, Mr. White. We have to. I don't want him to continually come back to this court with the same types of offenses. if he has any additional theft cases, it's soon going to be a felony. It's only going to get worse for him, is what I'm saying. So we need to figure out something that's going to assist him, whether it's mental health, whether it's alcohol, drug evaluation, whether it's some other type of monitoring that will assist him so that he can, so that he does not keep coming back before this court. What I want to do with the matter is I want to put it off for a week until next week's SAP calendar, because it's my intention at this point to accept the recommendation of the state and give him additional time. If you want some more time to figure out another alternative, Mr. White, I'm happy to do that, but I'm going to have some type of alternative that's going to assist him so he doesn't keep coming back before, and that I'm not setting him up for failure. I mean, if he's not complying, that'll give Ms. Falk and an opportunity also to see if he's complying with the probation that he's already on. If he's not complying with the probation, that term is coming up, it looks pretty soon here, then he's going to have a problem with that. If he has a problem paying the fine or doing the community service that's recommended here, then that's going to set him up for failure. So I also don't want to set him up for failure in that way. So let's see if we can, and if there is an alcohol drug problem, I'm happy to give him an alcohol drug evaluation in exchange for possibly some jail time, but we have to do something to assist him so that he doesn't keep coming back to this court. Okay, so 1 week reset should give us enough time for you all to maybe come up with another alternative for me, and Ms. Falk to find out about the probation for me. Okay?
That would be July 1st, Your Honor.
All right. So I'll see you back in a week, Mr. Coffey.
Next, Your Honor, we can go to position number 6, Ms. Bradley.
Did you have something else on that, Ms. Falk?
Yes, we're ready to proceed on that, Your Honor. I requested ACDC bring that up next.
Okay. Good morning, Ms. Bradley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. Yes, Ms. Falk.
Yes, Your Honor. On position 6 on the simple assault, the state's recommendation is going to be 12 months served 30 days, credit for time served 15 days. From June 10th, 2025, balance probated, 12 weeks of anger management, no further violent contact with Angelin Brady. On count 2, the criminal trespass, 12 months concurrent with count 1. We have had an opportunity to speak with Angelin Brady, and she is in agreement with this plea. We do ask the defense to stipulate to venue, factual basis, and identification the venue, factual basis, and identification for the purposes of this plea. That's all for the state. And we would like to sound for Miss Angelin Brady in case she is here.
Ms. Brady is on the line and wishes to address the court. Now is your opportunity. Does not appear so. Mr. Haddad?
Judge, we stipulate for purposes of the plea, I would ask the court to consider either waiving the couple months probation fees or on the back end, placing on non-reporting, assuming she completes all the conditions.
Okay,
State has no objection to non-reporting.
thank you. Ms. Bradley, it's my understanding that in case 25 CR 003271Y, you wish to plead guilty to simple assault, family violence, and criminal trespass and damage to property. Is that correct? Okay, I'm sorry, you have to speak up for me or come forward. Still can't hear you. Okay, very good. Are you under the influence of any drugs or alcohol this morning?
Not at all.
You've been represented by counsel. Are you satisfied with his representation?
Satisfied.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced you or coerced you to plead guilty?
Not at all.
I'll accept the plea as negotiated, Ms. Bradley. When you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay?
Yes, sir.
All right, good luck to you, ma'am.
Have a wonderful day.
You do as well.
Position 44, Mr. Price.
And Your Honor, this is a case that we believe the alleged victim, Bianca Kelly, was there present with Your Honor. And Mr. Price does intend to plead not guilty. I advised him of his rights, but he does intend to address Your Honor in the court directly.
Okay, good morning, Mr. Price. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Speak up for.
Rod Price.
Okay, so hold on, Mr. Price. I just want to let you know that you have a right to remain, you can put your hand down. You have a right to remain silent. Anything that you say can be used against you, okay? You have an attorney there that's representing you. I'm sure that he's advised you. We have a solicitor on the line. This is being recorded. Anything that you say can be used against you at a later time. Quite often, people want to tell me something, and I'm happy to hear it, but it's not in their best interest, okay? You'll have an opportunity down the road to litigate this matter fully. If you choose to do so. So it's my understanding that today you're pleading not guilty to the charge and it's going to be returned to the division judge. You'll get notification of your next hearing date. But I do understand that you want us to say something and I'm going to give you that opportunity, even if you are, it's not the advice of your counsel. So is there still something that you want to tell me this morning?
My name is Darren Sherrod Price, and I was born July 1983. I'm trying to see why everybody else is getting out of my name. I don't like the shit, so I don't want nobody to get out of that name no more. And then
Okay.
people told them that they locked me up on the Darren Price, because they'll never put my real name. They always put Darren Price.
Okay, I'm sorry, Mr. Price. I'm not understanding everything that you are saying to me.
Okay.
No, right there on the
Okay.
first bench. So can
Did you
see
want to
it.
say something else?
Y'all just let you know my name Darren Sherrod Price.
Okay. Yes, yes, Mr. Price. Anything else?
Yeah, I'm trying to see like how long when I go home. I don't really go back to my house when I go home.
Okay, so as I said to you, you already have a bond set for you. It's my understanding that you're pleading not guilty today. And because of that, your case is being reset or it's going to be returned to a division judge and you'll get notification of a hearing date. That'll be coming up.
I get a lower bond today. Can you help me out?
Okay, there's not been a bond request, for this charge. Did I set this bond? Do we know, Mr. Nixon? Do you have that?
Let me take a look. I know it was at a $4,000 surety, but let me. This was set by Judge Williams.
Okay, was there a mental health component of it set? Any requirements?
You say what, sir?
Hold on, Mr. Price. And tell me what the bond is, Mr. Nixon, please.
It's 15.
Sure, my Odyssey is a little slow, so give me 1 second.
Okay, I have,
1500.
okay.
Wait, I'm sorry. We don't miss the price. That's the wrong person. Let me go to price. It is 4,000 good.
And any stipulations on that? Stay away.
Let's see. And he's actually set for jail jury on 7/8, Your Honor. And let me see, he had to no further contact with Bianca Kelly, stay away from 767 Mercer Street Southeast.
Okay, so he's set for jail jury before whom?
Yes, for 7/8. Judge Taylor.
Okay, All right, so it's my understanding that he already has another court date that's set, so it's going to be with Judge Taylor on July 8th. So I will let Judge Taylor address any additional bond matters in this case when it gets to his courtroom. Okay, so you already have another date set, Mr. Price, that you're gonna be that you will be heard again. So you'll be heard by the division judge on July 8th. And
Right, so,
you can make your request at that time, sir.
So you gotta do the bond today, you can't knock it down.
No, sir.
All right, so it's on the 4,000, so it bond.
But what I would like to add to that, I would like for him to have a social worker visit before that time so that it can be reported to Judge Taylor if there are any issues with mental health. That might be of assistance to him.
So excuse me, what I'm saying, so right now, it's how much, 4,000, right?
Yes, it's my understanding that you have a $4,000 surety bond.
So it'd be 400 at the bond company,
I'm not sure of what that would be, sir.
and I go home today after I pay the bond.
That's correct.
All right, so then, thank you.
All right, good luck to you, sir.
You too.
Courtroom 2, if Alto Blocker, Jason Cox, or Andre Dox are in the courtroom, we could proceed with any one of those 3 cases.
Come on, Blocker. Okay. Got Mr. Blocker here.
Okay,
Before we start on that case, Ms. McLeod,
yes.
and she's ready for her client.
Okay, do you know who that is?
That's position 35, my mistake.
Oh, Miss McLeod's client.
Yes. And she has
Good
another.
morning, Your Honor.
Good morning, Ms. McLeod. So, have you all had an opportunity to get in touch with Ms. McClendon?
Yes, Your Honor, I have spoken with my client, and this is going to be,
Okay, my question, I'm sorry, Ms. McLeod, if the solicitor's office is getting in touch with alleged victims this morning. So we're having to hold on some cases for that. So I'm just trying to figure out if Ms. McClendon is one that we're still holding on.
Yes, and we have not reached out to, we are reaching out to Miss McFadden. I didn't know if Miss McLeod, if this was going to be a plea or not guilty waiver of arraignment.
it is going to be a non-negotiated plea.
Okay, so let me make sure that if we can circle back to that one, Your Honor,
Okay.
I'll reach out to our victim advocate and see where we are on updates.
Okay.
I have a calendar before Judge Edie right now, so may I log off and come back on once I've taken care of that?
Yes, that's fine, Ms. McLeod.
Thank you, Your Honor.
Okay, so this is position 5, Mr. Blocker. Is that right?
Yes, sir.
All right. And are we ready on Mr. Blocker here?
We are, Judge.
Okay, good morning, Mr. Blocker. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Yes, Ms. Fall.
Yes, Your Honor. On Mr. Blocker's case, the theft by shoplifting, state's recommendation is 12 months served, 42 days. Credit for time served, 21 days from June 4th, 2025 until today. Balance probated, a $500 fine, anti-theft course, 40 hours of community service. Stay away from the Walmart located at 970 Mansell Road in Roswell. Count 2, the criminal trespass, will be 12 months concurrent with count 1. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Mr. White?
Your Honor, we do stipulate for the purpose of the plea, and we just ask the probation terminate once it completes its requirements.
Okay. Mr. Blocker, it's my understanding that in case 25 CR 003176Y, you wish to plead guilty to theft by shoplifting and criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Absolutely.
You
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Blocker. When you complete the terms, I'll have the probation terminate. So the sooner you get that done, the sooner you won't be on probation. Good luck to you, sir.
Thank you, Your Honor. Thank you.
Do we have Nasheed Harper or Miguel Hernandez there, courtroom 2?
Hernandez is here.
Okay. Your Honor, that would be position 29.
Okay, thank you. Good. Morning, Mr. Hernandez. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
That's all.
Okay, thank you, sir. Yes, Mr. Nixon.
Yes, Your Honor. As for count 1, this will be 12 months to serve 64 days, credit for time served 32 days, and that's from May 24th, 2025 until today. Balance suspended, 40 hours of community service, $300 fine, stay away from Roswell Creek Apartments located at 881 Roswell Creek Lane. As for count 2, it'll merge with count 1. And as for count 3, 12 months to serve concurrently with count 1. And the state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
And defense so stipulates that is our understanding of what the state's offer was, and Mr. Hernandez does intend to accept the state's offer and plead guilty this morning.
Mr. Hernandez, it's my understanding that in case 25 CR 002955C, you wish to plead guilty to willful obstruction of law enforcement officers and criminal trespass. Is that correct? Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Hernandez. When you complete the terms of the probation, I'll have it terminate. So the sooner you get it done, the sooner you won't be on probation. Good luck to you, sir.
Go to ACDC, Judge.
Okay. Who do we have next? Do we have anyone at ACDC that we can take?
Oh, we do have a few cases here at ACDC, but I just messaged Ms. Scott, asked her if to give the positions I have already.
Okay, so,
I've got a couple of announcements in the meantime, Judge, that we didn't have on the original account.
okay,
Positions 2 through 4 will be a waiver.
okay, Mr. Bivens, waiver,
Brown, did we do that? No.
okay.
Did we handle 7 already, Brown?
Yes, we did.
And in position 19 is going to be a waiver as well, Judge.
19 Ellis, okay. Okay, and who do we have here?
Position 45, Mr. Richardson.
What are we doing with Mr. Richardson this morning?
Your Honor, I'm not sure if the state is ready for Mr. Richardson's case, if they've contacted the alleged victim. I was just in the process of attempting to reach out to her as well because what Mr. Richardson has informed me is that if the state is able to get in contact with her or I'm able to get her on the Zoom call this morning, she would testify that she does not reside at the incident location, that Mr. Richardson resides there, and we would ask for that to not be a part of the plea agreement, and that Mr. Richardson and the alleged victim do wish to continue having contact. We would ask for no violent contact, but of course, that's all pending speaking directly with the alleged victim for Mr. Richardson's case.
Okay. So as soon as we get that confirmed, we can move forward. Looks like Ms. Falk is. might
We
be-
are working on reaching out to Ms. Richardson right now, Your Honor.
Okay, all right.
And I'm just looking at the last positions that ACDC gave me to see if any of those we can move forward on. Position 36.
So give
But in the meantime, Your Honor, if we do have anyone over in courtroom 2, I think I called out a couple that we could move forward on. Myron Newton, if he's present. Also Nicholas Pittman, if he's present.
I need just a minute to speak with Mr. Pittman and then we can be ready.
We can go to add-on 1 and 2, Mr. Lindsay.
Okay.
He's not guilty. He's not guilty. Yes, I think he's not guilty.
Correct.
Come on, George.
So this is add-on calendar positions 1 and 2, Mr. Thaddeus Lindsay.
Okay.
Oh, then that's more stuff off, okay.
Oh, you talked to Mr. Haddad, Mr. Okay. It should happen for you to do. Add on 1 and 2 minutes. Okay, that's what's talking about. You heard us quick.
Okay, where are we?
Add-on 1 and 2, Mr. Lindsay.
Okay. And what are we doing with Mr. Lindsay?
That's Mr. Haddad's case, Judge.
That's fine.
Oh, I'm sorry. Negotiated plea.
Okay, thank you.
I'll be handling this.
Oh, okay, thank you, Mr. White. Good morning, Mr. Lindsay. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Sir.
Okay, you can place your hand down. Thank you, sir. Yes, Ms. Fall.
Yes, Your Honor, this is going to be a time served plea. The defendant has served at this point. Just pull up my other calendar. The defendant has at this point served 176 days, credit for time served 88 days from April 6th to April 16th, 2021 and April 9th, 2025 until today. The battery was null prossed on March 14th, 2022, leaving only the willful obstruction behind, and the state will null pros position 2 upon the acceptance of this plea. That's all. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
We do stipulate, Judge, and just ask that you accept the pleas negotiated.
Okay. Mr. Lindsay, it's my understanding that in case 21 CR 001646F, you wish to plead guilty to willful obstruction of law enforcement officers. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Sir.
You've been represented by counsel. Are you satisfied with his representation?
Absolutely.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated, Mr. Lindsay. Good luck to you, sir.
Thank you, sir.
You're welcome.
Position 48, Mr. Pittman.
I'm sorry, say that again for me.
Position 48, Mr. Pittman.
Position 43, Your Honor.
Oh, okay, thank you. And what are we doing with Mr. Pittman this morning?
Your Honor, Mr. Pittman is going to accept the state's offer. We would just ask that the $300 fine be converted to community service for Mr. Pittman.
Okay. Good morning, Mr. Pittman. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm that? Okay, there you go. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Correct.
Okay, thank you, sir. Yes, Mr. Nixon.
Yes, Your Honor. So count 1, 12 months to serve 40 days, credit for time served 20 days, and that's from June 5th, 2025 until today. Balance probated, stay away from 3625 North Commerce Drive, Atlanta. $300 fine and no weapons. As for count 2, 12 months to serve concurrently with count 1, 40 hours community service, and state would ask that this defense stipulate to venue, factual basis, and identification for the purpose of the plea.
And defense so stipulates, Mr. Pittman does intend to accept the state's offer. We would once again just ask that the $300 fine be converted to community service for Mr. Pittman. And as well, if Your Honor is amenable, that the fees associated with probation be waived for at least the first 3 months for Mr. Pittman upon his release, so he can have time to get his finances in order.
Is he in need of a social worker visit to assist with housing or anything of that nature?
My check stuff, I have 2 check stubs.
Your Honor, I don't think a social worker is necessary.
Okay. If nothing further, Mr. Pittman, it's my understanding that in case 25 CR 003202C, you wish to plead guilty to willful obstruction of law enforcement officers and loitering and prowling. Is that right?
Correct.
Are you under the influence of any drugs or alcohol this morning?
I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Correct. Wait, say it again.
You've been represented by counsel there. Are you happy with what he's done for you?
I am happy with what he's done.
Say it again for me. Are you or are you not happy?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Correct.
Has anyone forced you to plead guilty?
No.
Mr. Pittman, where do you have someplace to live?
I do.
Who do you stay with?
No one.
Okay, but you do have a place to go once you get out of custody?
I do.
Okay, I just want to make sure because if you don't, then I can help you with that, okay?
Correct.
Okay, all right. So I'm gonna waive the probation fees for him. And the sooner you get the community service done, I'll also have the probation go non-reporting once he gets the probation done. So the sooner you get that done, the sooner you're not gonna be on reporting probation, okay, Mr. Pittman?
Keep here one more time. No, sir.
So you've got some community service to get done. As soon as you get the community service all done, then you're not gonna be on reporting probation. I'm gonna have it go to non-reporting, okay?
Okay.
All right, good luck to you, Mr. Pittman.
Thank you.
You're welcome.
Are we changing that $300 to?
Yes,
Okay.
it's 30 hours of community service.
Position 18, the docks.
Also a negotiated plea.
That's correct, Judge.
Good morning, I'm Mr. Dox. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you, sir. Ms. Falk?
Yes, Your Honor. As to Mr. Doc's case, the state's recommendation on the public drunk is 12 months served, 30 days, credit for time served, 10 days from June 15th, 2025 to today, balance probated. Stay away from the Marathon Convenience Store located at 3257 Main Street in College Park, ADET, and random screens. On counts 2 through 7, the state's recommendation is 12 months concurrent with count 1. Your Honor, just to give you a little bit of background, all of these cases happened at the same location. So that's why we ran all the remaining counts concurrent. He just showed up at the same location over and over again on different dates in an intoxicated state. We do ask that the defense stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Okay, Mr. White?
Your Honor, we do stipulate for the purpose of the plea. We would just ask the probation go to non-reporting once he does his ADET. Underemployed.
Okay. Mr. Dox, it's my understanding that in case 25 CR 003174Y, you wish to plead guilty to 4 counts of loitering and prowling and 3 counts of public drunk. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Sir. No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Dox, you know you can't go back to that that Marathon convenience store, right?
Yes, sir.
All right, so make sure you don't go back there. And when you complete the terms of the probation, I'll have it go to a non-reporting status, okay?
Yes, sir.
Thank you, Your Honor.
Good luck to you, Mr. Dox.
Thank you.
Your Honor, positions 2 through 4, were those the waiver of arraignment not guilty
Yes.
cases? Okay, just wanted to make sure.
What's that?
Can we go back to position 41, Mr. Patterson?
Let me check on that really quick and see where we are with that one, Your Honor.
Okay.
One thirty-six or 134? Probation? 136.
Your Honor, this was a reset, so we may have reached out to this victim already. I just need to check our notes. And if so, we are ready to go forward. Your Honor, we're ready to go forward on this one.
Okay, thank you.
Sorry. Your Honor, this should be a negotiated plea for Mr. Patterson.
Very good. Good morning, Mr. Patterson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I plead guilty.
Okay, and you promise that you're gonna tell the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Patterson.
Okay.
Your Honor, I will just say one thing. We are going to we'll change the no further contact to no further violent contact with Guy Michelle. That is a police officer.
Okay. Mr. Nixon?
Yes, Your Honor. As for count one, this would be 12 months to serve 60 days, credit for time served 28 days. That's from May 28th, 2025 until today. Balance probated. No further violent contact with Guy Michelle. A stay away from 100 Peachtree Street, Northwest Atlanta. With reference to count two, 12 months to serve concurrent with count one, 40 hours of community service, and a $300 fine. The state would ask that the defense stipulate the venue, factual basis, and identification for the purpose of this plea.
Your Honor, we would, Your Honor, we would stipulate to, the facts of the case, Your Honor. We, are intending to plead guilty today, Mr. Patterson. We would just ask that the $300 fine be converted to community service. Mr. Patterson will, require the assistance of a social worker.
So, he's in need of help with, locating somewhere to, reside. Is that right?
That's correct, Your Honor.
Okay. Mr. Patterson, it's my understanding that in case 25 CR 003036 F, you wish to plead guilty to disorderly conduct and willful obstruction of law enforcement officers. Is that correct?
I plead guilty.
Are you under the influence of any drugs or alcohol this morning?
No, sir. He said I plead guilty to have something for me. Yes, sir.
Okay. You've been represented by counsel there. Are you happy with what he's done for you?
Yes, I'm happy.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anybody forced you to plead guilty?
No, they haven't.
I'm going to accept the plea as negotiated, Mr. Patterson. I will change the $300 fine to 30 hours of community service. I'm also going to waive your probation fees to help you stay on your feet. And when you complete the terms of the probation, I'll have it go to a non-reporting status, okay? So, sooner you get this done, the sooner you're not gonna be on reporting probation, okay?
When do I get out?
Okay, I'll let you talk with your counsel about that.
What's the next? Okay, thank you.
Your Honor, we're ready to move forward on Mr. Richardson's case. That was the case that Mr. Masajidin was going to talk to, asked about the stay away, and we are agreeable to removing that stay away. We'd had a previous conversation with the victim, and she is no longer at that residence.
Okay.
Also, as an announcement, position 49 and 50, Williamson, unless I am missing something, he was released. Yeah, they already caught that. Okay. Yeah, he's released. So he's not in custody anymore. We won't be moving forward on that.
And Ms. Falk, I would just ask if you had anything from the alleged victim regarding contact, whether she would be amenable to no violent contact or she wanted no contact absolutely.
Let me go back and look at her last notes. She did say, I think, that they were co-parenting.
That's what Mr. Richardson told me. They're co-parenting still.
So let me just double check. So we're fine with no further violent contact since they are currently co-parenting the child.
Okay. Good morning, Mr. Richardson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you, sir. Mr. Nixon?
Yes, Your Honor. As for count one, this would be 12 months to serve 80 days, credit for time served 40 days. That's from May 16th, 2025 until today. Balance probated, FVIP, 40 hours community service, no further violent contact with Stan Tricia Williams, no firearms, and alcohol drug evaluation treatment. As for count two, this would be 12 months to serve concurrent with count one. And as for count three will merge with count one. The state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of the plea.
And defense so stipulates, Mr. Richardson does accept the state's offer and intends to plead guilty this morning.
Okay. Mr. Richardson, it's my understanding in case 25 CR 002755G, you wish to plead guilty to battery, family violence, and cruelty to children in the third degree. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Richardson. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Is it for 402, right? Well, right now, I think it's eight.
Your Honor, we can move forward on some other cases, but I don't see any other defendants in courtroom two. So
Aye.
we can go forward on Jason Cox. We can go forward on Mr. Harper. I believe his name is Nasheed Harper. We can move forward on Myron Newton if he can be brought down to the courtroom.
Any updates on the women, Ms. Fall? We're still
Still
waiting.
waiting on updates.
right.
I do apologize. I have reached out to our victim advocate and asked her to specifically reach out to specific people. I went ahead and listed the people we need to have contact with.
Thank you.
Okay, stand by on those three cases. We have to go locate them.
Okay.
All right, I see that we have Mr. Jose Peterson on the DV bench warrant case with us. Mr. Peterson, are you there?
Yes, Your Honor, I'm here.
Okay, good morning, sir. Mr. White, has anyone had an opportunity to speak with Mr. Peterson this morning? Is that something that we can get you all to do? You're on mute there, courtroom two.
You can call us at the jail on, we can remember. 404-612-2060.
So, Mr. Peterson, I'm gonna have you take this number down and we'll have you speak with the public defender this morning. Okay?
All right.
All right. Are you ready to take the number down?
Yes, 1 second. What is it?
Oh, he's on his way.
I'm sorry, what was the number?
Go ahead.
404-612-2060.
That's with Evan.
404-612-2060.
Correct.
All right.
Okay. Go ahead and give them a call. Thank you.
All right. Thank you, sir.
You're welcome.
Your Honor, if I could ask if we could take just a brief 5-minute recess and I can get an update.
Okay. Court be in recess.
Thank you.
Hold on, I'm gonna take it one, okay?
The one that did not do today, six times, the one that say did not make it home.
Ms. Young.
I'm gonna sit down. I know you will.
Your Honor, so I don't echo. Yes, sir.
I've got an announcement, we need to change. Position 22, we had as a waiver. He has apparently changed his mind and would like to enter a plea, so we're just gonna reset him next week. He's already been taken back to the floor,
All right, 7-1.
but and it doesn't have to be 7-1 either. He's got another 46 days to do on this plea, so
Okay,
whatever's easiest.
I don't think the 7-1 calendar has come out yet.
it has not, but
Is it full?
it's 28. He could go on 7-1, that's fine. It's 27 on, yeah, let's put him on 7-1.
It works for us.
And Miss Young, we do have some resets the state is requesting.
All right.
So on position 13, the state is requesting a reset as to 13 and 14, Devontae Cook. He does still have jail time. The state was asking over and above the time he served. So if we could reset those to 7-1.
All right, Devontae Cook.
Position number 19. state-
Hold on. I'm sorry,
Oh.
Ms. Falk. There's
Yes,
already
sir.
there was already a request to reset, I believe, Mr. Cook till 7-8.
Oh, okay. 7-8 is fine.
Okay,
Okay.
that's very good. Hey.
My apologies, Your Honor. I was
No problem.
just looking at my side. I wasn't looking at the announcements. That's my fault.
Okay. Any others, Ms. Falk?
Yes, Your Honor. The position 19, was there any announcement on that one?
Just talked to him this morning. He's a waiver.
Okay, great.
And we're ready for Mr. Peterson and everyone else is. So.
Okay. We do have some more announcements. Position number 25. State would be asking for a 1-week reset on that case.
Do they have more jail time than 1 week? Can they go to 7-8?
They do have more jail time than 1 week. So yes, that could go to 7-8.
Okay. And what position was that?
I'm sorry, position, are we talking about position 25?
Position 25, we did agree to reduce the jail time on that, didn't we, PD
Okay.
Haddad? Okay, so we're gonna hold off on that one and see if we can get in touch with the victim in the next few minutes.
Thank you.
Position 35. I know that's Miss McLeod's case. We would ask for a 1-week reset. Miss Young, there is more jail time than 1 week. However, Miss McLeod is asking for a non-negotiated plea on that.
All right, thank you.
So we're gonna reset that 1 week?
If we could, Your Honor.
Okay.
And position number, I think that may, position number 47. I don't see announcement on that one from the PD's office.
That's a private counsel, Adric Walker.
Okay. Do we know if Mr. Walker is in court today? Ms. Young, do you know if he has filed a waiver or anything?
I don't see a waiver. I can try.
From Ms. Falk, on that case, Damon Walker was on several SCA for Mr. Walker, and whatever that last day, he finally actually appeared and apparently.
Right.
So anyway, he's got felony charges too, if I'm not mistaken. Damon
Right,
Walker.
I remember that. He had felony charges related to this, actually related to the same victim. I know he appeared on SCA after a couple of days, but I don't recall him doing any kind of waiver or anything else to have this case taken off the SAP calendar.
He did not. He did not.
Okay, got it.
The announcement from 610 was emailed and contacted Attorney Walker in reference to the case, and they left a voicemail, and Attorney Walker also has not filed an entry.
Oh, okay. So then can we reset that to either 7/1 or 7/8? Because if he hasn't filed an entry of appearance, then that may need to be handled by the public defender's office.
Okay, let's do 7/8, please, if that's okay.
Okay.
Okay,
Not trying to bog us down the day before the holiday.
No, I totally understand.
Or the
And that's all the announcements at this time from the state, Your Honor.
okay, thank you. So if we're ready on Mr. Peterson, Mr. Peterson, can you join us on screen there?
Yes, Your Honor.
Yes, good morning, sir. I'm Judge Eric Morrow. This is the DV bench warrant calendar. I take it, Ms. Falk, are you handling this, Mr. Nixon?
Yes, Your Honor.
Okay, yes, I take it that Mr. Peterson missed a court date.
Yes, Your Honor. It's the FTA is June 3rd, 2025.
And can you tell me whose court that was and what type of calendar?
This is Judge Edie in a plea and arraignment.
Okay. Mr. White?
Yes, Sean, I spoke with Mr. Peterson, and he did know that the date was June 3rd. He had been reporting, to pretrial, monthly, and changed his address with pretrial, but didn't realize that he needed to change it with the court. So, this is the only court date that he's missed on this case, but he has subsequently changed his his address with the court. And, we don't expect this to be a problem going forward. We just have to set aside the bench warrant.
Okay, so and Mr. White is right, Mr. Peterson, you have to change your address with the clerk. So if you move again, you need to go ahead and do that. I normally give people one chance to miss a court date. This is your opportunity. If you miss another court date, the bench warrant won't be set aside, okay?
Thank you so much, sir.
You're welcome. So make sure to stay in touch with the court or with the clerk's office to see when your next date will be. All right, so Mr. White will prepare that set aside. You'll get notice of your next hearing date, sir. Good luck to you.
Quick question, sir. Will I get an email sent to or like a notification sent to my email
No.
regarding my hearing?
Your notice should come in the mail.
Okay.
So, but you can check online as well, Fulton County, website. And a lot of times you can find out if you've got a court date coming on. I would recommend doing that every couple of weeks just to make sure.
Okay, will do. Thank you.
All right. Have a good day, sir.
You as well,
Free to
sir.
go. Thank you.
Your Honor, on the SAP calendar, we're ready for position 7, Nasheed Harper. Or 27, sorry. Nasheed Harper.
And what are we doing with Mr. Harper this morning?
Your Honor, Mr. Harper, is prepared to plead guilty today. We just asked that, the probation, which is being recommended by the state, be non-reporting for Mr. Harper.
I have that in Mr. Harper's case, position 27, that balance is suspended.
Yes, sorry, Your Honor, I missed that. So, Mr. Harper is ready to plead guilty this morning.
Okay. Good morning.
Yeah. My apologies, Your Honor, we are ready.
Okay. Good morning, Mr. Harper. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down. Thank you, sir. Yes, Mr. Nixon.
Yes, Your Honor. As for count one, this will be 12 months to run concurrent with count two here. And as for count two, 12 months to serve 40 days, credit for time served 20 days. And that's from June 5th, 2025 until today. Balance suspended. Stay away from 3002 Gardner Drive in Alpharetta. And the state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
And defense so stipulates that is our understanding of what the offer was. Mr. Harper does intend to plead guilty this morning.
Okay. Mr. Harper, it's my understanding that in case 25 CR 003191G, you wish to plead guilty to loitering and prowling and criminal trespass. Is that correct?
Yes.
Yes or no?
Yes, Your Honor.
Okay, so you do wish to plead guilty to loitering and prowling and criminal trespass. Is that right, Mr. Harper?
Yes, Your Honor.
Okay. Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel there. Are you happy with what he's done for you? Okay, so you've been represented by counsel there. Are you happy with what he's done for you, Mr. Harper?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Harper. Is he gonna need some social service help, counsel?
No, Your Honor, I don't believe so. There was just some hesitation because I had missed that the state wanted to suspend the probation and Mr. Harper was unsure if he was going to be on probation or not. So that's my mistake. There was a little bit of confusion, but I've explained it to him. I don't believe there's a need for social work.
Okay, very good. Good luck to you, Mr. Harper. Now, do we know, what is the 3002 Gardner Road address? Is that, Mr. Nixon, what type of address is that? Do you know? I don't want him getting in trouble for going back there, so I want to make sure that he knows where that is.
Let me check again. I'm not. This property man, I think it's an apartment complex. Yes, apartment complex.
Okay, so you can't go back to that apartment complex, Mr. Harper, okay? Okay, good luck to you, sir.
All right.
We can go to Jason Cox, Judge. That's position 15.
Okay. And this is a negotiated plea.
That's correct, Your Honor.
Good morning, Mr. Cox. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Is that a yes?
Yes, sir.
Okay, thank you. Yes, Ms. Falk.
Yes, Your Honor. On position 15, Mr. Cox, the state's recommendation is to the count of theft by shoplifting is 12 months, served 36 days, credit for time served 18 days. That is from June 7th of 2025 until today. Balance probated. Stay away from Green's Liquor Store, which is at 737 Ponce de Leon Avenue in Atlanta. A $500 fine, anti-theft course, and 40 hours of community service. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Your Honor,
We do stipulate for the purposes of plea and just ask the probation terminator go non-reporting once he completes his requirements.
And is he gonna be able to pay the fine, Mr. White?
I asked him yesterday and he said he would.
Okay. Mr. Cox, it's my understanding that in case 25 CR 003245H, you wish to plead guilty to theft by shoplifting, is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning? Say it again for me if you responded.
What, wait, he's,
No, sir.
Okay, so my question was, you need to explain something to me, Mr. White?
he's a little quick on the draw. He is answering, but I think there's not enough time between you finishing and the lag.
Oh, okay, thank you. So let me ask you that again. Are you under the influence of any drugs or alcohol this morning, Mr. Cox?
That's right.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Cox. When you complete the terms of the probation, it'll go to a non-reporting status, okay? Good luck to you, sir.
Thank you, Judge.
You're welcome.
And Your Honor, we're prepared to move forward with the remaining cases.
Okay. So who do we have next?
Position number 30, Ms. Ingram.
And this is going to be a negotiated plea, is that correct?
That is correct, Judge.
Good morning, Ms. Ingram. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, speak up. You have to speak up.
Yes, Your Honor.
Okay, very good. Thank you, Ms. Ingram. You can place your hand down. Yes, Mr. Nixon.
Yes, Your Honor. As for count one, this would be 12 months to serve 30 days. Credit for time served 15. And that's from June 10th to June 10th, 2025 until today. Balance prorated, 12 weeks of anger management, 40 hours community service, no further contact with the victims, Celestine George, stay away from 121 Cleveland Avenue Southeast, Atlanta. And as for count two, it'll merge with count one. And the state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
Just to make sure, Mr. Nixon, you said merge. I've got on my sheet as concurrent, so I just need a clarification of what's going to happen with that charge.
Yes, I believe for Ms. Ingram, we've agreed to, the state and the PD's office has agreed to a merger.
Your
Okay.
Honor, I think it's essentially kind of a null cross merger because it's the same allegation for both counts. Just charged differently. One is a battery and simple battery, but the actual act is the same.
Okay. Yes, Mr. Dottie.
And we so stipulate, Judge, I would ask the court to either waive a couple months probation fee or non-reporting at the tail end of the case, assuming she complies with everything. We've already given her the housing information as well. She's been in contact with Women on the Rise as well, Judge, I believe.
Okay, so at the present time, there's an issue with housing.
But that is correct, Judge.
Okay. Ms. Ingram, it's my understanding that in case 25 CR 003279B, you wish to plead guilty to battery, is that correct? Say it again for me.
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Ingram. I'm gonna waive the first 2 months of your probation fees to help you get on your feet. And once you complete the terms of the probation, I'll have it go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, ma'am.
All right, thank you, sir.
Okay, now do. Okay.
Who do we have next?
ACDC, you're good to call your positions up.
Position 36, Ms. Moore.
Also a negotiated plea?
Oh, yes, Judge, it is.
Okay, good morning, Ms. Moore. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Say it again for me.
Yes, sir.
Okay, very good. Thank you, ma'am. You can put your hand down. Yes, Mr. Nixon.
Yes, Your Honor. For the simple battery, this would be 12 months to serve 32 days, credit for time served 16 days. And that's from June 9th, 2025 until today. Balance suspended. No further contact with the victim, Roebuck Latonia. 8 weeks anger management and 40 hours community service. The state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
Okay, so if you have balance suspended, I take it you mean balance probated if she has to do some type of something that needs probation?
Yes, Your Honor.
Okay. That's your understanding, Mr. Dodd, I take it.
It is, Judge.
Okay.
And we stipulate, and I would just ask the court to consider non-reporting upon completion or terminating upon completion, well, non-reporting upon completion of all the conditions, Judge.
Okay. Ms. Moore, it's my understanding that in case 25 CR 003261G, you wish to plead guilty to simple battery, is that correct?
Yes, sir, it is.
Are you under the influence of any drugs or alcohol this morning?
Absolutely not.
You've been represented by counsel. Are you satisfied with his representation?
More than.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Moore. When you complete the terms, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay?
Okay, thank you.
All right, yes, ma'am. Good luck to you.
Thank you.
Okay. Give me 1 second. We have someone at the doors and G33, so we don't have anyone in here with us right now. Give me 1 moment. Okay, who do we have next?
Got Mr.
Good
Newton,
morning to them,
Myron Newton.
but he can attend
I
via.
have a question before I log off.
Question for,
Is position 35 and 25, they're both reset, right?
I'm sorry, I can't hear you. Say it again?
Is position 25 and 35 reset or?
Position 20, 35, we're ready to move forward on. Position 35 is the reset, Your Honor.
It's reset to 7-1.
Okay, so who do we have? Who would you all like to do next?
Got Mr. Myron Newton here.
And tell me the last name again. I'm sorry, I didn't catch it.
Newton.
Yes.
Newton, okay.
What's the jail phone? What's this jail phone number? 612.
And who's representing Mr. Newton?
I believe he has private counsel listed, Shannon Render.
I'm on the phone with Mr. Render right now, trying to get in contact with him.
Okay, so,
Okay.
can we go to someone else while we wait for Mr. Newton's counsel?
Yes. You do position number 35, Ms. Briggs.
Ms. Griggs, the recommendation is gonna be time served, okay?
And that is a modification from Your Honor's calendar. I'd spoken with PD Haddad and we came to that agreement when he counteroffered.
Can someone tell me the position number, please?
Position number
Oh, my
25.
apologies, Your Honor. It's position 25.
25, okay,
But we did add some conditions, so I will put those on the record.
okay. Yes, good morning, Ms. Griggs. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, ma'am. Yes, Ms. Falk.
Yes, Your Honor. On Ms. Griggs' case for the battery, the state's recommendation is going to be 12 months, serve 32 days, credit for time served 16 days from June 9th, 2025 until today. No further contact with Bobby Beasley, 12 weeks of anger management. Stay away from 4795 Main Street in Union City. We also agreed to 40 hours of community service as an addition for the reduction in the service time. And on count 2, 12 months concurrent with count 1, a $300 fine. Count 3 will merge with count 1. As part of this negotiation, the defense has also agreed to seek no termination or no termination and no non-reporting as a condition. We do ask the defense stipulate to venue factual basis and identification for the purposes of the plea. That's all for the state. And we would like to sound for Mr. Bobby Beasley if he is here today.
Mr. Beasley is on the line and wishes to address the court. Now is your opportunity. Does not appear so. Mr. Haddad?
Judge, we stipulate, for purposes of the plea, I would just ask the court to consider waiving just the first couple months of probation. So, thank you.
Ms. Griggs, it's my understanding that in case 25 CR 003263A, you wish to plead guilty to battery and willful obstruction of law enforcement officers. Is that correct? Do you need? Okay.
Yes.
Okay, so you wish to plead guilty to the battery and the obstruction of law enforcement. Is that right, Ms. Griggs?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel here. Mr. Haddad, are you happy with what he's done for you?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Griggs. I'm going to waive the first 3 months of the probation fees to help you get on your feet, okay? Good luck to you, ma'am. Ms. McLeod, did you only have that one case before me this morning?
Yes, Your Honor.
And I believe that the state has asked that that case be reset. Give me 1 second, ACDC. That case be reset. Is that right, Ms. Falk?
Yes, Your Honor. We asked it be reset 1 week to July 1st.
Can you tell me what case that was again?
That was position number 35, which is Miss Natasha McClendon.
Well, Your Honor, I was hoping we could hear the case. At the very least, if I could ask a signature bond for my client, if the state is not willing to go forward on the plea, because it was going to be a non-negotiated plea. And the only issue was the jail time.
Right, Ms. McLeod, we have not been able to, due to a miscommunication, we are having, we had to reach out to the victims this morning. We have not been able to reach out to her. So because of Marcy's Law, I cannot proceed on that case. And I do apologize sincerely. That's why I asked for a 1 week reset instead of to reset to July 8th, because I knew you were asking for a non-negotiated plea.
Right. Is my client there to hear all of this? Is she hearing all of this?
She is in ACDC currently, Your Honor. So I believe they can hear all of this.
Yeah, I believe she's before us.
Okay.
Okay,
Ms. McClendon, did you understand what just happened?
Ma'am. No, ma'am. No,
Okay.
ma'am.
Your Honor, is it possible to explain to her what happened, that the state
Oh.
asked for reset?
okay. The state is asking to have your case reset, Ms. McClendon, given that they have not been able to get in touch with Ms. Tamika McFadden, the alleged victim in the case. What does the calendar look like on Thursday?
Thursday is 20, let me see how many people actually, how many got out of jail.
And I will be on Thursday.
Okay, so why don't I do
It's fine on
that?
Thursday.
Okay, I hate to reset this a whole week. So why don't we go ahead and, I'm gonna reset it till Thursday to give them the opportunity as opposed to next Tuesday, okay?
Thank you, Your Honor.
We'll see you back on the 26th.
26. Thank you, Your Honor.
Oh,
You're welcome.
Thursday coming up, Your Honor. You wanna do add on for Thursday coming up?
Yes, and that's 26th.
Okay,
Yes, Your Honor.
I was looking at the third, I'm sorry.
Okay.
Clarify.
All right, so this Thursday,
Okay.
2 days from today. Okay, we'll see you back then, Ms. McClendon.
Thank you, Your Honor. May I be excused?
Yes, have a good rest of your day.
And thank you, Ms. McLeod, for your
You're
understanding.
welcome. No problem. Thank you.
Are we done at do we have anybody else at ACDC?
Your Honor,
No one else at ACDC.
Say it again for me.
There's no one at ACDC. Your Honor.
Okay, so thank you all. Yes, Ms. Fall.
Your Honor, the only positions remaining unaddressed on the calendar is 37 and 42 based on, I just went back over the calendar. Those are the only two that are remaining. I think 42 is the one where there was 37 was the one where there was a private counsel that Mr. Mahajadan is trying to get in touch with. I don't know what the announcement is on 42. I don't have an announcement on 42. I think that might be a private counsel as well.
So for positions 37 and 38, that's Mr. Newton. He did inform me that he had Shannon Render as a hired private counsel. I reached out. I was only able to speak to a secretary or a paralegal. They said that Mr. Render is not in the office, but that they would pass along the message. I let them know that he can attend court via Zoom, but that's all that I know right now on Mr. Newton's case.
And Your Honor, reviewing my notes on position 42, I believe that's a conflict case that Ms. McLeod was at first at SCA, but those were my notes, Judge. I can go back and examine it more closely, but that's what I have, Judge.
Okay. So these are both time served cases, so I'm hating for them to sit in custody for another week, if need.
Yes, Your Honor, Ms. McLeod is on Mr. Peters.
Okay. Can we get in touch with Ms. McLeod to see? I just let her go. And as far as Mr. Newton goes, I don't think, we can't move forward with him, so given that it's uh, if the plea offer is taken, it would be time served, I'm gonna reset him for, Thursday as well. 6:26.
They're supposed to be.
I see that we have Mr. Harris on the line as well, for the DV bench warrant calendar. Mr. White, are you going to,
So did you log in? right?
will you speak with Mr. Harris?
I will, Judge.
Okay.
I've got
Okay, Mr. Harris, good morning. This is the public defender I'm gonna have you speak with, so if you could take down the number. Do you have something to take it down with? If you can unmute yourself there for me.
Okay.
Mr. Harris, are you with me?
Yes, sir.
Okay, do you have something you can take the number down with?
I'm finna get some now.
Okay, go ahead and do that.
And in the meantime, PD Haddad, it was a failure to appear at plea and arraignment on June 4th, 2025 before Judge Richardson. Just so you have all the information before you go talk to Mr. Harris.
You mean, Mr. White, correct?
You're welcome.
Now, Mr. Harris?
No, Mr. Harris.
The DV bench one.
Yes, sir. You can. I'm ready for the number.
Okay.
404
404
612
612
2060.
2060.
All right, go ahead and call me right now.
Okay.
Your Honor, I'm calling Ms. McLeod. I'm also in charge of getting interpreters like, Ms. Cardiva.
She said plain arraignment, right? I was so confused because she was talking. That's what I thought I heard.
Yes, June 4th, plea and arraignment before Judge Richardson.
Ms. Falk, are you with me?
Yes, Your Honor.
I don't know if you are aware, but I have a motions calendar this morning, that I was going to hear in G33 for,
Yes, Your Honor.
okay, and
I
was just-
notified. Oh,
Okay, no, I was just wondering if we have, solicitors that are gonna be on with me.
I notified Mr. Rosenberg and Mr. Ham of the calendar, Your Honor.
Okay,
So they should be there shortly.
okay, I just wanted to make sure. I know I don't have a deputy in the courtroom with me, so everybody's outside, but I just wanted to make sure that somebody's here. All right.
And let me just confirm with them to make sure, but I did notify them when the calendar came out.
Okay, I appreciate it. Thank you.
It was recent. I was supposed to be non-negotiated.
And he's going to reset thing. We're ready for Mr. Harris whenever you are, Judge.
Okay. Let me give Ms. Falk a moment.
I'm ready, Your Honor.
Okay, so if you'll unmute there for me, Mr. Harris. Yes, good morning, sir. I'm Judge Eric Morrow. This is the DV bench warrant calendar. It's my understanding that you missed a plea and arraignment calendar on June 4th before Judge Richardson. Mr. White?
I'm sorry, Judge. I missed that. Just distract me for a second.
I was just informing Mr. Harris of what Ms. Falk had informed us of earlier, that he missed the court date for Judge Richardson on June 4th for plea and arraignment.
That's correct, Judge, and he had moved and was not aware that any changes addressed with the court. He was informed by pretrial that he missed the court date. He immediately went and did change his address. This is the first time he's missed court in this case. We just asked that you set the bench warrant aside.
Okay, Mr. Harris, I typically allow people to miss court on one occasion. This is your one time to miss court. You have to make sure that you stay in touch with the court or with the clerk to let them know when you change addresses. So if you miss court again, the bench warrant will not be set aside, okay? You will get notification of your next court date before Judge Richardson, and we expect that you'll be there.
Okay.
All right. If nothing further, good luck to you, Mr. Harris.
You said what, sir? Can you repeat that?
Yes, you're free to go this morning.
Okay, thank you.
Okay, so I think that we're still trying to get in touch with Ms. McLeod.
I've sent her an email and I've called her, Your Honor.
Okay. That's position number 42. So I believe, is that right?
Yes, Your Honor.
Okay. Given that this is a time served offer as well, I don't want them to have to sit in jail any longer than necessary. So I'm going to reset this for Thursday as well,
Okay.
6/26.
6/26. To take the plea and I'll email her. And Your Honor, that was Mr. Harris from the bench warrant, right?
Yes,
Okay, you just put him
set aside.
set aside. Thank you.
Okay. So I believe that completes the 9 o'clock calendar. So as soon as you're ready, Ms. Young, we can go over that.
Yes, sir. Position 1 is reset to 7/1. Position 2, 3, and 4 are jail jury. Position 5 was a plea. Position 6 and 7 were pleas. Position 8, 9, and 10 reset 7/1. Position 11, jail jury. Position 12, jail jury. 13 and 14 is reset to 7/8. 15 was a plea. 16 and 17 was released, Your Honor. Reset further notice. Position 18 was a plea. 19, jail jury. 20 was a plea. 21, was that released?
I have reset jail jury on 21.
Okay, 21, jail jury. All right. Position 22, reset 7-1. Position 23 and 24. Not for sure what happened. Can we call those out for me?
23. Oh,
Go, no,
sorry, Your Honor.
go ahead, Ms. Fall.
I have reset jail jury on 23. On 24, he was released and reset further notice.
Thank you. 25.
7-8.
Negotiated plea. 26.
That was transferred to the DA's office. The order was signed yesterday.
And I sent, and I CC'd you in the email.
Mhm.
27 was a plea. 28 was a plea. 29 plea. 30 plea. 31 was a plea. 32 is jail jury. 33. What happened with 33, guys?
Released.
Released.
Okay, thank you. Reset further notice. 34, reset 7-10. 35, reset 7-26.
626, Ms. Young.
Yes, thank you.
Thank you.
How about doing the add-on calendar, the road thing? 36 was a plea. 37 and 38. Mr. Newton, did he take a plea?
No, we reset him for 626 because it's a time served plea and he has a private counsel.
Okay. 39, reset further notice was released. 40, same announcement, released. 41, negotiated plea. 42, reset 626. 43, plea. 44, jail jury. 45 was a plea. 46.
Released.
Released further notice.
47, reset 7-8. 48 was jail jury. 49, reset further notice, and 50, they both were released, same defendant. Add on. Here. Add on was a plea. 2 was non-pros. 3 was a plea, and 4 was non-pros. DV, reset further notice, both bench warrants were set aside on 1 and 2. That completes the call of the calendars, except for our motions, Your Honor.
Okay, let's see, if no questions or concerns, those of you that don't need to be around for the motions calendar are free to go this morning. Have a good rest of your day. I'll see you next week. Ms. Greenhouse, I'm gonna need for you to stay around for me, if you would, please. Thank you.
And Your Honor, just to confirm, Mr. Rosenberg should be coming down or should be down already to handle that motions calendar.
Okay, thank you. I appreciate that.
And if you have, if there are any difficulties, feel free to give me a call and I can see what I can get done.
Okay, thank you.
Okay, thank you.
Thank you, Judge.
Thank you. Y'all have a good day. Miss Grace, are you with me?
Yes, sir.
I need, if you wouldn't mind, to have someone get in touch with the sheriff's office. We don't have anybody in here right now, so before we can start these, I'll need for there to be a deputy.
Ms. Strong said she talked to the sheriff's department. They said they were on their way down.
Okay,
Okay, thank
all right, thank you.
They send their stuff. I can give it to you to sign.
Yes, come on up, Mr. Blassingame. Uh, Good morning. We're here on the matter of case 22 CR 007935A. Derek Blassingame versus State of Georgia, and 24 CR 006069A, Derek Blassingame versus State of Georgia. Good morning, council. Good morning, Mr. Blassingame. I understand that there's some motions that are pending in regards to these two cases. One of the motions is one for expungement or restrict or seal certain counts. Does counsel for the state have any objection to those motions?
I do wish to be heard on those, Judge, yes, actually.
Okay, given that you do, I'm gonna have Mr. Blassingame present first, and then I'll come to whatever objections you have, okay? Good morning again, Mr. Blassingame. If you'd like to present, you can go ahead.
This microphone is. This microphone is.
You don't know how you at the podium.
It is.
That one.
Okay,
So pretty much, I thought we were here regarding 22-00793 5A. And in reference to that, I'm more so concerned about the motion for court-appointed counsel for the purposes of appeal to Georgia Court of Appeals, because they were waiting to proceed on my case, but I don't have a court-appointed attorney. And so, because I can't afford an attorney, I would ask the court to appoint one for appeals.
okay.
He qualifies.
All right, I'll take a look at it and take that under advisement. Anything further, Mr. Blassingame?
Because about that motion in December or January, and this is now in June, so I'm not sure what's taking the court so long. I mean, the Georgia Court of Appeals is going to either, issue a remitter, or they're not going to hear the case because of this court's delay. And so, I would appreciate a decision as soon as possible. In reference to my motion for court-appointed counsel. The other thing in reference to 22.
Did you file I didn't see in the file a motion for court-appointed attorney. I saw an affidavit where I allowed you to get any documents that you needed for appeal. Listen to me. But I did not see within your motions a request for counsel.
Okay.
And specifically, I heard this case at the trial level, you did not want to be represented by counsel
That's right.
at that time. I did not see anything formally filed within this case regarding your request for counsel at this time. Did you file something?
It should be on that case, yeah, because that's one of the things I emailed the court staff.
Do you have a copy of it?
No,
for the court?
not it should be issued. If not, I would like to go on the record and actually do a motion right now on the record on this date to have a court-appointed counsel, just in case somehow the clerk's office deleted it from the file, because that's happened in my case previously. I was able to prove it to Ms. Alexander. But in reference to the court-appointed counsel, I would ask I'll do a verbal motion for it now to have a court-appointed counsel for the appeal.
Okay, so, but I want to get it because you've alleged that your case has been delayed because you had not been, that a motion had not been heard. Again, I don't see anything, and I've checked this docket a number of times where you have requested a counsel to assist you in this case. If you have something that you can show the court where you have requested counsel, I'll be happy to look at it. But I don't want you trying to say that the court has done something when there's not been something before the court to rule on in that regard.
There was a file, and
Okay.
I would need to pull up that file, but there was a file. I attempted to look at it in the.
Excuse me, Your Honor. I'm sorry to interrupt. I just need, if the gentleman could speak a little closer to the microphone.
Okay.
Thank you.
I've been attempting to speak closer to the microphone, but you all are getting feedback in the courtroom. Okay, so
Continue.
Like I said, just for procedural purposes, I'll do a verbal motion to request court appointed counsel in regards to the appeal. You all just transmitted the transcript yesterday, according to the record that I looked at today. So just sent over 6 months after I filed the motion for appeal. The transcript was just sent over to the Georgia Court of Appeals. So there has been some delays in the 22 CR 007935A case, but last week, there apparently was some resolution with, or the week before last, with getting my probation terminated in reference to that, because I completed the terms and conditions of probation in December of 2024. Me attempting to get the record updated and the probation to do that, that's already been resolved. So my argument in reference to the court not doing what it was supposed to do was related to that. Now, I did also take issue with the fact that I appeared before Judge Roth multiple times in reference to terminating my probation, and he said he couldn't do it. It was your case, and his signature is on the notice of probation for termination for probation. So I just do I think there was some little games that was played, but obviously I don't want to get into that because the probation has been terminated and this case has been resolved. But I do want to also entertain the fact that the individual charges that were no prost or dismissed for want of prosecution, as a matter of law, I'm entitled to record restriction on those charges that didn't result in a conviction. In reference to 22 CR 007935A.
Okay.
And in reference to the second case, I would like a separate hearing on that. On the 24, I think it's 006069A.
Hearing on both those right now. So
Well, I don't want to mix both arguments together, but in reference to the 24 006069A case, that case resulted in the state not prosecuting, and it was no prost, and I'm entitled to a record restriction in reference to that because there was no conviction.
okay. All right. Thank you, Mr. Blassingame. Counsel.
I would also ask that if should the court grant my motions, that I have time, because I spoke to the clerk's office this morning and I just got back in town. I need a copy of the file, and they said they can produce that by disk within 5 days. So I would need time to get all of my record off of all of the files off of those cases, both of them. Thank you.
I'll try to speak loudly and slowly. On the 22 CR case, I guess, if he's entitled to an attorney or if he qualifies for court appointed counsel, then the state has no objection, as I've stated.
Excuse me, Your Honor. I'm sorry again. I just need the solicitor to speak closer to the microphone, please. And also, if I could just have the solicitor identify himself. Thank you.
Yes, certainly.
Did we try to turn these on at the?
We did.
Okay, and they.
I can, whatever. All right. Ms. Greenhouse, can you hear me if I speak like this? Okay. Now we can't hear her. That's perfect.
You're on mute, Ms. Greenhouse. Can you?
She's got it. I think she's got
I'm
it.
sorry. Yeah, yes, I could hear that. Thank you. And I just need you, if you don't mind, if you could just state your name, please.
Yes.
Thank you.
My name is Stephen Rosenberg. I'm with the Office of the Fulton County Solicitor. I'm here on behalf of the state. So with respect to the 22 CR case, Judge, I would cite the statute itself, OCGA 35.337. I think it's I2, and that talks about when someone is eligible for a record restriction. And it says, after the filing of an indictment or accusation, right, which we had here, the filing of an accusation, an individual's criminal history record information shall not be restricted if the charged offenses were tried, which they were, and some, but not all of the offenses resulted in an acquittal, which is exactly what we had here, because actually some of the offenses, one of the offenses in particular, the court directed a verdict of acquittal, which is in fact an acquittal. So under that statutory provision, he's not entitled to have his record restricted. I would also sort of point out that case is up on an appeal. I think the court probably retains some jurisdiction so that it could restrict it if it chose to. But, you know, I think the better practice probably would be to sort of wait to see what happens with the criminal appeal. But regardless, I think the face of the statute provides that when you have a case that's actually tried before a jury, and some of the cases are convictions and some of them are acquittals, an individual is not entitled to record restriction. So that's on the 22 CR case. With respect to the 24 CR case, I will be as candid with the court as I can, and I spoke to Mr. Blassingame in the hallway about this. I think he's entitled to a record restriction on that case. The entirety of that case was null prost. However, I would point out that in the null pros order, the court you stated, or the court you wrote, the record is not restricted. So essentially what I think Mr. Blassingame had to do was ask for an amendment of this null pros order. But he's out of time. You've got to file a motion to amend such an order within the term in which it's entered. And in this case, this was entered in the November-December term of 2024. He filed his motion in the January term of 2025. So, you know, I think as a technical matter, he's out of the term, he's out of time in terms of asking for the relief that he wants. But as a substantive matter, he's probably entitled to have that record expunged. So I'd leave it in the breast of the court and just point out that issue.
Okay. What about on counts D and E for the ones that were null prost? On the 22 CR 007935A case.
Yeah, you know, I think that those are because, and I don't remember the specific timing of when they were null prost. I thought they may have been null prost. I don't know if they were before or in the midst of trial. And I don't know. And frankly, as I stand here, I'm not certain that matters. I would state that again, I don't think because of the conviction, he's entitled to an expungement or a record restriction on those counts. Because of, again, the I-2. And then I also think, frankly, because it's up on appeal, the court should at least withhold ruling on that until such time as the case actually goes up while it's in the Court of Appeals right now. And then, you know, they make a decision and then come back down, because could be, you know, it's conceivable we're back here doing this again. So, yeah.
Okay,
Thanks, Judge.
thank you. Anything further, Mr. Blassingame?
Yeah, so in reference to the 22 CR, the CR 22-007935A case, the Georgia Court of Appeal, Georgia Supreme Court, and I don't have the case law, but I can brief the court later this afternoon on that particular case that determined that in the interest of the criminal justice reforms that the state of Georgia has undergone since 2011 under Governor Nathan Deal, the purpose of record restriction does allow for any charges that were dismissed or null pros, because it would defeat the purpose of in the interest of justice for persons to have charges appearing on their criminal background checks for employment or housing purposes if there was no finding of guilty or there was no conviction. The purpose of the interest of my interest in pursuing employment opportunities and housing opportunities outweighs the public's need to have access to criminal charges that did not result in a conviction or a guilty finding by a judge or a jury. So the state's desire and effort to deprive Mr. Blassingame of his privileges that are afforded him with not having those convictions is to me is moot because he went through the process, the criminal justice process, and those charges were dismissed for some of them were dismissed for want of prosecution and no prost, or just dismissed simply because the witness did not appear for trial. So I think that in the interest of justice and the fact that Mr. Blassingame already gave the criminal justice system here in Georgia 3.5 years of his life, which included homelessness, having to see a counselor and indigency and things of that nature. I think that those factors should be considered along with the fact that there was no conviction. So I think that the statute is clear and also case law is clear that the Georgia Supreme Court does allow for individual charges to be restricted, not necessarily the totality of the case. The case number just stands for, it's just for the purpose of, for the clerk's purpose of identifying individuals who are charged with criminal offenses. but the charges are what the jury considered. And some of those charges were dismissed prior to, or didn't even make it to the jury. So such as the disorderly conduct, that was something that was a directed verdict of not guilty because obviously there was enough evidence at trial that supported a not guilty finding in that regard. So I just think in the interest of criminal justice reform here in Georgia, that it would be in the best interest of the court to restrict those portions so that Mr. Blascam can obtain employment opportunities where people won't have to see that he was charged with making terroristic threats, which there was no criminal, no trial or no proceeding. It's just this ire of he was charged with that. That charge was dismissed at the arraignment because the judge asked them specifically, do you have enough evidence to proceed with this? And they didn't. So the judge dismissed it. So I would ask that the court consider those factors. And the fact that somebody who's looking at an employment background, I would say, well, he was charged with terroristic threats. Well, why didn't he get dismissed off his record? There's so many things that are out there that would prevent somebody from getting opportunities just because it's there on the public record. And again, in the interest of justice outweighs the need for the public to have access to that information. Thank you for your time.
I'll take it under advisement and get you all the order out in the next few days. Nothing further. Y'all have a good rest of your day. Ms. Greenhouse, thank you so much.
Thank you, Judge Morrow. Have a good day.
You the
Bye-bye.
same.
Thank you.